Okay, great. Awesome. Well, thank you so much, everybody, for joining us. Thank you, first and foremost, Tom, for joining us. As I mentioned, but for those that didn't hear this the first time, you are clearly beloved in this industry. And so we're very grateful to you for taking the time away to talk about a bunch of incredibly important topics. As everybody knows, we will, of course, record this session and we will make it available on Turn and Learn for people to access as is needed. Before we dive into the amazing content that Tom has prepped for us, I want to start with introductions. So maybe we'll start on the Turn side, and then Tom, will turn it over to you last, and then we can just go ahead and dive right in. I'll kick things off and introduce myself, and then also a few kind of housekeeping items. So on the housekeeping side, myself and Aaron will be on the chat and on the Q&A box. If you have a specific question that you're hoping that Tom or the Turn team will answer, you'll go ahead and navigate to the Q&A section in the bottom Zoom panel. Go ahead and click on that and answer and ask your question there. We will be actively kind of monitoring that. It just helps us keep it a little bit more organized than the chat. Now, of course, feel free to use the chat, say hi, use it to sort of hype things up, whatever feels kind of best for you. But the Q&A box will be the place that we will be actively kind of monitoring questions and then making sure that we ask them aloud towards the end of our Q&A session. We're going to start first. Tom's going to walk through a deck, and then we're going to talk through things. We'll kind of intersperse with questions where is relevant, and then we'll open it up at the end for Q&A. I think that's all the housekeeping stuff. Erin, am I missing anything before we dive into intros?
No,
Good?
you got everything.
Amazing. Okay, great. Well, with that, hi, everybody. Thank you so much for taking the time. My name is Katie. I am one of the 3 co-founders here at Tern. It's one of my great privileges to have been able to consistently meet so many amazing human beings in this industry as we've started to build this product. All of our amazing guests and advisors on the call, all of you being a bunch of those folks, and then of course Tom too in the industry. So many other great experts that we've had the privilege of learning from as we've been building up and scaling this business, which I am endlessly grateful for. So that's me. I will turn it over to Aaron next.
Hi, I'm Erin. I joined you guys last week for our live training session, and here I am again. I'm new at Turn. I'm with this customer support specialist extraordinaire, Ellen, and also with Katie. You might have talked to any one of us whenever you submitted a question in the queue or submitted a feedback request. We are always so excited to hear your thoughtful and detailed feedback because it just makes Turn better. So happy to be here.
And Tom, over to you.
Okay. Well, I'm going to just start with my presentation because it's got a little bit about me in there. So I'm going to share. I'm Tom Carpenter. I am a travel agency owner, just like many of you. I'm a travel advisor, just like probably all of you. I'm also an attorney in private practice who represents a lot of clients in the travel and tourism industry, mostly small businesses like travel agencies and tour operators. A couple of professional responsibility disclosures just to get those out of the way. The states where I'm licensed might view this as attorney advertising, so I need to make that disclosure here. This is for informational purposes only. I am not intending to give specific legal advice to any of you about anything in particular. I'm speaking in generalities. And by participating in this webinar, that does not create an attorney-client relationship between your business and my firm, unless I already represent you, which I see a lot of people who I do. So still, I'm supposed to say that. So, and lastly, prior outcomes don't guarantee future results. So if I talk about, a court case that was decided one way, that doesn't mean that we're going to get the same result the next time a court looks at it. So just to get that out of the way. I've been practicing law for a really long time because I'm super old and tired. I've been representing clients mostly in the arts and entertainment industry for most of my career, but also in the travel industry. I used to run the legal department at AFTRA. I lost a year of my life putting the merger together with AFTRA and Screen Actors Guild, and then I worked on Broadway for Actors Equity for a while. Now most of my practice rather is representing small travel agencies and tour operators. I am admitted to the state bars in New York and Illinois, as well as a few federal courts, including the United States Supreme Court. I don't do litigation, however, so if you need me to go into state court, I can't do that in your state, most likely, unless you're in New York or Illinois, but I wouldn't because I don't do litigation. But I have clients everywhere on transactional matters. I represent at least 1,500 travel agencies and tour operators all over the place. And in addition to my law practice, I also own a small hosted travel agency. So shout out to all my Uniglobe family. If you've seen other presentations I've done, you've probably seen a version of this slide, which basically is kind of the underpinning of pretty much everything that I do when I represent my travel industry clients, which is manage legal risk, because travel is a high risk industry. There's fraud, there are scams, there are risks when you're handling client payment information, which we're going to talk about here. Chargebacks are a huge problem right now. When clients are traveling, think about all the things that can go sideways on a trip, everything from a sudden pandemic shuts down the industry for 2 years, or terror threats, civil unrest, the wars, natural disasters, fires, floods, hurricanes. All of those things are disruptive and present touch points for legal risk. Supplier default and bankruptcies. American Queen recently went bankrupt. So I have many clients who are owed commission from American Queen. There's a European tour operator, which I just heard today went out of business, and a lot of clients are stranded. So those bankruptcies can be a real problem. And then legal compliance and disclosures, because travel is a highly regulated industry. And even in the United States, where it's less regulated than in other countries, there are certain things that we have to comply with. So the good news is, I'm going to say a lot of things that are probably going to scare the heck out of people on this call, but the good news is that all of those touch points for risk are things that can be managed or mitigated in some way. So we're going to talk about a few of those things, and certainly having errors and omissions insurance is really important. You're going to want to have a well-crafted terms and conditions document. And if there are people out there who think that that's optional, get ready to have your socks blown off. Having a solid and consistent workflow is just as important as having good documents and policies, and having a good tech tool that implements it. And so I'm grateful to Tern for inviting me to talk about this. I've been really excited when I've been working with them about making how they can make their platform easy for compliance and hardwired to really give you the right tools that you need to protect your business. Following best practices when collecting payment information and getting credit card authorizations, that's another place where Tern can really help you. And I'm sure they'll talk more about that too. Okay, so let's start with errors and omissions insurance. Some people think that they don't need a terms and conditions document because they've got errors and omissions insurance. And then there are other people who think, why am I paying for errors and omissions insurance when I've got a terms and conditions document? So everybody should have errors and omissions insurance. It is not a good idea to operate your business without it. Errors and omissions insurance is supposed to be there for you if you make a mistake, and simple human error happens. So think of this as professional negligence insurance. If you weren't careful and you mess something up and you have to pay for it, that's what your errors and omissions insurance should be doing for you. If you are a hosted advisor and your host agent has an errors and omissions insurance policy that covers you, I think that you should get your own policy in addition to what your host agency has, because that policy that your host agency has probably has a really high deductible. It covers hundreds, if not thousands, of other businesses. And if one of those agencies has a claim that sucks up all the coverage limitations, there's not going to be a whole lot left for you if you have to file a claim after that. So you may need to add the host agency as an additional insured party. There's nothing nefarious about that. You want your host agency to be protected. If you have to file a claim under your policy and they get dragged into it, it doesn't cost you any more. So just look at your contract with your host to make sure that you're in compliance with that. And I think even the smallest businesses are going to want to have at least $1 million in coverage. Depending on how much you book, you might want even more than that. A couple weeks ago, I talked to a client who told me that she priced out 500,000 in coverage and 1 million in coverage, and it was only like $30 a year more to have 1 million in coverage. So start with that. And if you've got a significant book of business, maybe even go up a little higher. Okay.
Hey, real quick, Tom,
Go ahead.
before we move on from E&O, question for you. There's a couple of like relevant questions. So if so long as this format feels comfortable, I'll try to like keep them topically relevant. Is that okay?
This is great. Yeah, for
Okay,
sure.
perfect. So there's a couple of questions on, well, one, if we're an independent contractor, do you recommend that we set up as an LLC?
I do. Actually, it's funny, like on other iterations of this, I have a slide for that. If you are a sole proprietor, you and your business are one and the same. You are your business. So if somebody sues your business, it's like they're suing you. And so if you have to pay a fine to the government, if you have to pay a judgment to a court or to a litigant, um, your personal assets are at risk. So your house, your retirement savings, your car, all of that stuff can be attached to a judgment against you. If you're a limited liability company, well, if you're a corporation, the corporation insulates your personal assets from the liabilities of your business. The problem with a corporation is that you get taxed twice. Your business gets taxed once, and then you get taxed as an individual. The LLC is kind of the sweet spot in between those things because the LLC protects your personal assets from the liabilities of your business, but you have a lot of flexibility in tax treatment. So you can be taxed as a corporation if you want to be, if there's a reason that that's advantageous to you. And I'm not a tax attorney, so full disclosure, I'm not giving tax advice here. But an LLC will protect your personal assets from the liabilities of your business. So for most travel advisors, for most small travel agencies, setting up as an LLC is going to be the sweet spot between protecting your assets and flexibility on tax treatment.
Super.
I see the next question. I'll just go ahead and answer it. There are two companies that do provide E&O insurance that insure most of the world. One of those is Berkshire Hathaway, and the other is Aon, which is AON, capital A, capital O, capital N. Just one thing to say about that. Berkshire Hathaway in particular has started taking the position that if you do a lot of FIT trips, that you are functioning as a tour operator. I don't agree with that from a legal perspective, but if the insurance company tells you that you need tour operator policies, you should put the policy in place that they tell you you need to have, because if you don't have the right insurance, that's a really quick and easy way for them to deny a claim. I see client agreements. We'll talk about that in a little bit. For tax attorneys, I would recommend that you, if you don't know somebody in your local community, you can reach out to your local bar association to see if they have an attorney referral program, and they might be able to put you in touch with somebody who they would recommend. That's what I would recommend. Okay, now I'm going to get to terms and conditions, if that's okay.
That's perfect. Thank you.
Okay. So a terms and conditions document is a document that is contractual in nature. It's between you and your client, and it's the boilerplate for all the trips you do. Because it is a legal agreement between you and your client, you need your clients to actually agree to it. So like putting it on, we'll talk about this a little bit more later, putting it on in the footer of your email and saying, by reading this email, you're agreeing to my terms and conditions. That is not a thing. That doesn't work. It doesn't count. You need them to actually agree to it. I have a strong view. There are lots of places you can get your terms and conditions documents. There are free templates floating around out there. There are services you can subscribe to. I have a strong view that you really want to have a terms and conditions document that is custom for your business, because no two businesses are alike. Somebody who does a lot of destination weddings might need different terms than somebody who does corporate travel versus somebody who does adventure travel. If you have any specialties or niches, you're going to want to make sure that your terms and conditions document is actually protecting you. And the other thing I would say to worry about or to pay attention to is there are often things that are in those forms, those cookie cutter documents, that are problematic. There are some that have tour operator provisions. There are some that have arbitration clauses, which, you know, any of those things could be really problematic if you get into a dispute. So I would strongly recommend talk to a travel lawyer about putting something together that really is going to protect your business and not just something that was drafted generally, because there is so much risk here. Okay. So what goes into a terms and conditions document? When I draft terms and conditions documents for clients, there are pretty much 5 main categories that I put into the document. I'm going to, the Q&A is distracting me, so I'm going to close it. Okay. So the provisions that go into your terms and conditions document generally fall into one of these 5 buckets. The first is legally required disclosures. So I mentioned that that travel is highly regulated. There are certain things like seller of travel laws. You need to disclose your seller of travel number or your host agency seller of travel number. There is a federal law that requires you to disclose that airline tickets have an expiration date if you sell airline tickets. The Department of Transportation requires you to make hazardous materials and insecticide notice disclosures whenever you sell an air ticket. So you can put a lot of those terms and conditions, a lot of those disclosures that you are legally required to make into your terms and conditions document. And that saves you the hassle of having to go and make those in some other way by having a conversation with your client, sending them another email, getting them to sign a whole other form. Put it in your terms and conditions, it's easy. The one really important category are provisions that make it clear that your role as a travel agent is different than your role as a travel advisor. And I'm going to talk about what that means. So when you are a travel agent, you are a booking agent for the supplier. So you have a fiduciary duty to the suppliers that you book, meaning you're not allowed to undercut their pricing unless you're Costco, in which case you do it all the time. You're not allowed to misrepresent their product. So your role as a travel agent is really important because you have those obligations flowing to the supplier. And then your role as a travel advisor, you are, you know, similar to a financial advisor or some other advisor, you are advising your clients on what they need to know in order to travel. So you have a duty of care that goes to this advisor as well. So that being in that middle place where you have obligations, legal obligations that are flowing in 2 different directions, that is a complicated place for a travel agent or travel advisor to be. But when we say that, you know, we talk about ourselves as being travel advisors now, we're actually both. We're both a travel agent and a travel advisor. And so in your clients, in your terms and conditions document, provisions that clarify your role, what it is and what it isn't, are really, really important to have in place. Advisories to clients, these are a little bit different than legally required disclosures. I spoke to a client just today who had somebody show up at the airport with her baby to get on a flight to Mexico, and the baby didn't have a passport. And she didn't think that she would need to say to her client, oh, make sure that the baby has a passport, because she thought they knew that. Fortunately, she has terms and conditions that I drafted for her, which make that clear. So the client had agreed that they understood that they needed a passport. So if the conversation doesn't happen, it's in your terms and conditions. There are lots of other things, advising people on risks of travel and safety. You know, a lot of people know about the lawsuit against that was brought by a Texas firefighter against a travel agent because the travel agent supposedly said, oh, it's safe to go to Mexico. And then something bad happened. Well, you can advise your clients that if they have concerns about travel, they can go to the State Department website. They can go to the CDC website to see if there's a coronavirus problem. So you can make all of those advisories in your terms and conditions document. One I've started putting into documents now, advising people that they can't transport, possess, or use illegal drugs. Now that marijuana is legal in so many places, you don't want to have a Brittany Griner situation on your hands. If somebody tries to get on a cruise ship with their weed gummies and they're denied boarding, making those advisories is really important to protecting you because they can't say that you never told them. Cancellation and refund policies. This is super important. That if your clients, I'm sorry, yeah, your clients can agree to the cancellation and refund policies through your terms and conditions document. If you advise them that there are cancellation and refund policies in place, that is really important for protecting yourself against a chargeback. We'll talk a little bit more about that later. And then the last ones, and these are some of the most important provisions, limitations on liability and force majeure. So I put a provision in every document that I draft for people. As I said, they are customized, but this goes in all of them, that the client agrees that because you are the booking agent and not the supplier, that you are not responsible for anything that your suppliers do or fail to do that leads to damages, injury, loss, or anything like that. So that could be as simple as you book your clients at a resort, they were supposed to have a view of the ocean, they checked in late, the hotel moved them to the back of the hotel overlooking the dumpsters, they're upset at you because you put them at that resort. Well, you don't have control over what the front desk does in that when they handle that reservation. So your clients can agree in your terms and conditions document that you are not responsible for that and that they can't come after you because the hotel messed that up. It could be something more serious, like your client gets horribly injured in an accident because the motor coach went off a cliff. It could be even can protect you in cases of supplier policies that your clients don't like if there's a no refund policy or a future travel credit instead of a refund policy. Your clients can agree that you're not responsible for those policies. And even if the supplier declares bankruptcy and fails to deliver the services entirely, your clients can agree that they are not going to be able to come after you because your clients are because you don't have responsibility for the financing that the supplier has. So they can take you off you can take yourself off the hook for that. I also put a provision in every document that says that because you are paid based on commission and fees, that if the supplier or if the client does try to sue you, that they agree that their damages are going to be limited to your commission and fees. So whatever you made on the trip and any fees that you charged. So if they try to sue you for $30 million and you only made $750 on the trip, they can agree in your terms and conditions that they would never get more out of you than $750, even under the worst case scenario. So that's obviously important. Force majeure, some people call those the act of God provisions. That is just basically anything that's unforeseen, unpredictable, outside of your control. Pandemics, quarantines, natural disasters, fires, floods, hurricanes. If those things make it impossible for you to do something you're supposed to do for your client, the force majeure policy says you're off the hook. So a big storm rips through your community, knocks out your power, you missed a bunch of payments. Your force majeure clause says that you're not responsible for the payments you missed because the storm was the reason you couldn't do it. So those are the five main categories, and there are different provisions that fit in with different ones. There's some overlap as well, but basically a good terms and conditions document has all of that. And again, just to stress, it should be custom for your business. Like, if you do culinary tours, I might put something in your provision that says that you're not responsible if a kitchen doesn't respect their dietary restrictions or their food allergies. Just because you sent them to that restaurant or put them on that cruise ship for the food. So those customizations are really, really important. Okay. The one thing that you can't put into a terms and conditions document, but it's really, really important, and Tern can help you do this, you need to disclose who your supplier is, because if you don't disclose who your supplier is, then courts will assume that you are the supplier, and then you suddenly become responsible for anything that goes wrong on that trip. Somebody gets sick, somebody dies, you're on the hook if you didn't disclose who the supplier is. I know a lot of people like to white label things and want to leave the supplier off. But when you're building the itinerary, Tern gives you the functionality to identify who the supplier is. If you've got terms and conditions that have a provision requiring your clients to agree to the supplier terms, you don't have to get them to separately agree to the supplier terms. You don't have to send them another form saying agree to these, but you do need to provide them with access to those terms so that and the principal way to do that is by identifying who the supplier is. And keep in mind too, that clients often don't understand your role as the booking agent. They might think that you are in charge of everything that happens on that trip. And if that's the case, you definitely want them agreeing to your terms, and you definitely want to be disclosing who the supplier is. So I'm going to pause there just to see what other questions we have. I'll go back to, now I'm going to open the window because it's not going to distract me.
Yeah, and feel free, Tom. So I'm moving some of the things to the answered column. So I'm happy to kind of read aloud in aggregate some of the top questions that have come in, if that's helpful. The first is about the kind of cadence with which people should be updating their terms and conditions. What are the best practices there for how frequently they should be revisiting those?
Yeah, my friend and colleague Jeff Ment, who's another travel industry attorney, he thinks that people should probably update them once a year, or at least check and see if an update is needed once a year. I try to when I draft documents, I try to draft them so that they are not so that they stand the test of time and that you're not constantly having to revise them and update them. That having been said, I also, when I draft terms and conditions documents for my clients, I keep an eye on, any new regulations that we need to put in place. If there's something that comes up, I send around updated language to my clients. I don't charge for those updates because it's really just me sending out a newsletter, to be honest. But if something changes in your business, certainly, if you develop a new niche or a new specialty, I would recommend that you contact your lawyer to talk to them about whether or not your terms, if you're booking a lot of skydiving trips and you're like, holy smoke, am I covered for this? You can call your lawyer and say, hey, my business is taking this turn. Just want to make sure I'm protected. So that's what I would say about that.
That's super helpful. Thank you. Yeah, we had quite a few questions around that. And then the question that I kind of want to weave in a little bit of sort of like the Tern lens on this, because we worked obviously very closely with you to think about how we weave advisor best practices around terms and conditions into our product and how we support that. And I think the big question that we kind of consistently get, and I think there's sort of differing views on this in the industry, is the difference between one set of terms and conditions and like multiple sets of terms and conditions. And so, I mean, obviously I know kind of the quote unquote right answer given our work with you being that there should be really kind of one terms and conditions that sort of applies to the entirety of your business. But can you maybe just speak to that? Because that question comes up quite a bit.
Yeah, so I do think that you want your terms and conditions to be drafted in a way that they cover all the different types of trips you book, because lots of there are very few people who only book one thing. So I would just recommend that you not have multiple terms for different types of trips. The client agreement, which we're about to talk about, is where you can be kind of flexible and adaptable. I don't put fees in my terms and conditions document, for example, because I'm going to talk about this in another slide, actually. But I don't put my fees in my terms and conditions documents because you might want to charge different fees to different people. You might want to waive your fees or make an exception. So I don't think that answers the question, though. What am I off base?
No, that's exactly it, Tom. I think, yeah, I think it is actually the answer to this question is the distinction between agreements from terms and condition. And so it was, yeah, meant to be sort of a segue for kind of your next topic, because I do think the question comes up a lot because I feel like because it's hard to sort of decipher what the difference is and how to use both and have them pair eloquently with one another, which is kind of the strategy. And so, yeah, so if you want to dive into that, that's great.
Yeah. So you've got, it's not enough to have all these really great protections in a document. You need your clients to actually agree to it, because it's not a contract if they don't actually agree. And that's where I think the client agreement comes in. So, unfortunately, Tern has the ability to make this really easy for you. So what I recommend doing, and this is what I do in my agency, we upload our terms and conditions to our website. We tuck it away someplace, and then when we work with a new client, we reach out to them and send them a client agreement, which is like a little form to fill out where they give us their name, address, date of birth. And then they agree on that form to our terms and conditions. They agree to our fees. They agree to that they understand that we always recommend travel insurance to people. But again, you can be flexible and adaptable with your client agreement. Tern has the functionality that you can actually upload your terms and conditions into Tern. But if we are my agency is in the process of moving over to Tern from a different system where we built a customized form, and they just check a box. I agree to your terms and conditions, which are located at www. wherever you've posted it. But here's why you need both. So the terms and conditions document, that's all the legal stuff. That is the same for every trip that you book, for groups, for your FIT, corporate travel, leisure groups, whatever. Leisure travel. It's a one size fits all. It's the baseline for everything that you do. And I don't recommend that you ever make exceptions or waive any of your terms, which is why I recommend putting the fees in your client agreement. So you can have different client agreements for different clients. You can have you could have one for your standard clients that are booking trips with you. You can have one for guests to the destination wedding. You can have a client agreement for multi-generational family groups. That's where you can be flexible and adaptable. You can reinforce important terms from your terms document, but you just want to make sure that it's consistent. And the other thing that I like about using a client agreement is I really feel like it creates a mindset with the client that prevents them from kicking the tires. Once they've checked a box that I'm hiring you to plan my trip and I agree to your terms and conditions, and they've submitted that form, it creates the idea for them that, oh yeah, this is the person I'm working with. This is my travel gal. This is my travel guy. And I think it just prevents them from shopping around, checking you on price and things like that, when they feel like they've committed to you. Workflow is super important. And Tern is all about the workflows. I recommend that you keep your workflow as simple and linear as you possibly can, because especially if you're an advisor who has sub-agents, if you have ICs that are working with you in your agency, you want your workflow to be easy to manage, because if it's too complicated, if there are too many steps, that's when your ICs start cutting corners and making stuff up as they go along. You don't want them doing that. And also, you want to be really easy to work with from your client's perspective. You don't want to be rubbing their nose in a bunch of legal stuff. You want to be you don't want to be constantly sending them forms that they have to fill out. So the easier and more streamlined you can make it, the better off. So this is like a simple workflow. You do an intake call. They sign your client agreement at the front end of the relationship. You work on a quote for their trip, send them a discussion draft itinerary, fine-tune that and book it. After you booked it, you send them the quote for insurance, and then you follow up with them post-trip. Simple, linear, easy, breezy, beautiful cover girl. Okay, so what I said earlier, I really do feel like it's really important to get your clients to agree to your terms and conditions without rubbing their nose in the legal stuff. It's not a contract if they don't agree to it. So you can upload the terms to your website to make it conspicuous, and then use Tern to build a custom form, or you can upload it directly into Tern so that it's fully integrated into your workflow. Checking a box is enough to form a valid agreement. They don't have to sign it wet ink on paper, but they do have to actually affirmatively agree to it. Whether your client reads your terms, that's up to them. I mean, look at this lovely couple. Maybe they've just made sweet love. I don't know. But they're booking a trip now because they're very much in love, and they are agreeing to the terms and conditions, and they're not even paying attention to what they're agreeing to. So The one exception I would say is waiving a legal, I love this picture, by the way. Waiving a legal right, that is something where you need a signature. And so there are things that I don't put in terms and conditions documents because those are waivers. So sometimes people will ask me, can we put a photo release in my terms and conditions document? I don't recommend doing that because under state law, people have what's called a right of publicity. They have the right not to be used in advertising for commercial businesses. And so if you're asking them to give you advance permission to use their vacation photos on your website, you need to get them to sign something, either an e-signature or wet ink on paper, but you need an actual signature because you're asking them to waive that legal right. So here you go. So the tech tool is a really great way to get people to agree to your terms and conditions. If you are using a tech tool, you need one that is going to allow you to create custom forms. You're going to need one that's going to allow you to transmit credit card numbers in a secure and encrypted form. Having some sort of e-signature function is important because you may actually need a signature if you're asking them to waive things. And then you're also going to need a system that keeps a record of tracking when your clients have submitted those forms, when they've agreed to the credit card authorization, when they've agreed to your terms and conditions. And all of these things are built into Tern. So it's really going to take the guesswork out of a lot of that for you. And now I'm going to pause because I'm sure we have more questions now.
Yes, I can hop in and ask a few questions for you. So we had quite a few people ask this, and obviously you don't have to give an exact number, but what should people expect to invest in terms and conditions? Because it's incredibly important. It's good to set expectations, but ballpark, area, range of cost for investing in a good terms and conditions.
Yeah, so yeah, and it's something where I couldn't give you a number here anyway, just because this is going to be recorded and somebody's going to watch it later on and maybe the rates have changed.
Absolutely.
But when I draft terms and conditions documents for people, I try to keep the cost reasonable. I know that small businesses don't have unlimited resources to spend on things, but so I try to keep it around the range of a mid-range booking, one mid-range booking. I think there's at least one other travel industry attorney who thinks I don't charge enough for that. I do it on a flat rate because I do so many of them that I can do them quickly. I include, in addition to drafting the terms and conditions, I include talking through the workflow, how to use a client agreement, giving you a template of a client agreement, credit card authorization language, fee structure, insurance waivers, all of those things. So it's a kind of a package that covers you from start to finish when you're booking with your clients, but we're not talking thousands of dollars, we're talking hundreds of dollars. I would say in the upper hundreds of dollars.
That's really helpful, Tom. Thank you. And just so you know, we linked your contact form. We know that obviously everybody's business is different. So these are custom quotes and rates. And so if folks want to reach out to you directly, we linked your contact form for the sake of this being purely informational.
I'm glad that I made the advertising disclosure policy or disclosure before. But the other thing I would say too is if you're even for my standard packages that I do for people, I have a different I have a different rate for tour operators for people who function kind of as a hybrid, and but I'm also part of the ASTA attorney referral program, and my rates are discounted for ASTA members as part of that program. If you're not a member of ASTA, I would encourage you to join. I'm a huge supporter of theirs. I think they do so much good work to protect our industry, and they deserve your support. And if you're working with me, your membership would probably pay for itself.
That's awesome. Super helpful. Okay, a couple kind of more specific questions. I'll just read them verbatim that sort of speak to the topic we're covering right now. A question from Rebecca on timing. She said, I'm working with a few clients on upcoming trips. I'm an independent contractor working within a larger agency. I don't have terms and conditions. Is it too late to have them sign? We've begun the process, and in some cases, they've paid deposits.
So that's actually kind of a good segue to the next section, which is credit card authorizations. What you need to do, you need to have your clients agreeing to your terms and conditions as part of every credit card transaction. And so if you've got clients that have put a deposit down on a trip, but they haven't yet traveled yet, and if they haven't made their final payment, you can have them agree to your terms and conditions as part of the when they authorize you to run the charge on their card for the final payment. If you've got people who have paid in full and they just haven't taken the trip yet, I think it's probably going to be a little clunky to get them to agree to your terms and conditions at this late date. But that's also probably a narrow universe of people. So I would say, you might want to just, cross your fingers and hope for the best for those folks. But if you've got people who've started the process, it doesn't have to take a long, well, my calendar's a little bit backed up right now for consultation appointments. It doesn't have to take a long time once we start the process to get something put in place. I have two other attorneys on my team who do review calls. Sam and Rebecca are both terrific. They take really good care of my clients. And so if I don't have time available to review the document with you, you could talk to them. But once you get the document in place, you can have them agree to it as part of the credit card authorization. So credit card authorizations. Here's the thing. You need to get a credit card authorization each and every time your client authorizes the transaction. And it needs to show the date that the transaction was authorized, the amount that was being authorized, and the supplier and product or products. You can, aggregate things and, if you itemize things, this, and this is the total, they can authorize the total, but you need to be able to show something in the event that there's a chargeback or a credit card dispute. Do not take credit card numbers by email or by text, and avoid taking them over the phone as well. Do not set up a just charge my card that you have on file thing with your clients, and don't store your numbers in an unsecure, unencrypted system. And I'm just going to tell a couple of horror stories. I have a client that I've been working with right now who was communicating with her client over text messages. She had been quoting a price per person throughout. Her clients asked her, quote, give me a quote per person. They asked, what's the cost? There were 4 people traveling. Client says, what's the cost of what's the cost of a business class ticket to Europe? The advisor said $6,000. The client said, go ahead and book it for me. The advisor took the number over the phone and then put through 4 charges for $6,000 for 4 business class tickets. A few hours later, the client calls back and says, why do I have 4 charges? Why was I charged 4 times? Now, I mean, I don't know any universe where you can get 4 business class tickets to Europe for $6,000, but this client is now saying that that was not an authorized charge, that she didn't understand that the 6,000 was per person, not per for 4 people. And because the advisor didn't get a written authorization to run the charge on that card, and because they didn't send an invoice where it was itemized and automated, that advisor is now on the hook for that mistake, a really, really expensive mistake. And so if the client does a chargeback, the credit card company is going to go to the supplier and say, prove to us that there was authorization for this charge. And then the supplier is going to come to you and say, prove to me that you had authorization to use your client's card. And if you can't do that, the supplier is going to send that to recovery, and they're going to make you pay for the amount of the chargeback. So, you can put something in your terms and conditions document, which I always do, that says that the client's not going to do a chargeback. But if they do one and you wind up having to pay for it, you're potentially going to have to sue your client to get that money back. And there's no guarantee that you're going to get it back. And it's going to cost you money to get the money back too, right? So So the consequences for not getting a credit card authorization each and every time is it's just really, really expensive. And I know that a lot of people say my clients aren't going to tolerate that. They're not going to want to log in and do that each and every time. And, I guess the question is, are you prepared to pay for it? I mean, if it's a $25 charge, maybe it's fine. Maybe you can ignore that, but really, it protects your clients because they know that your credit card number is being charged. When somebody files a chargeback, I think a lot of times they think that they're getting their money back from the credit card company. They don't realize that what they're doing is they're reporting it as a fraudulent charge. And if you're the one who used their card to run that charge, it's kind of like they're accusing you of credit card fraud, which is serious. That's a serious thing, right? So get credit card authorizations each and every time for every charge. Tern makes that easy. It's not a burden on your client. They just log in, click, 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 and then it's authorized. And you've got the magic language, which I'm going to talk about now. During the pandemic, the credit card companies changed their standard for how they resolve credit card disputes during the pandemic. They are now requiring that you have it. Well, first of all, that you have a terms and conditions document. So if you don't have a terms and conditions document, that's straight. You're already knocked out of the box. The client has to agree to your terms and conditions as part of the credit card authorization. The terms and conditions have to include language about cancellation and refund policies. And this is the new thing. Now the cancellation and refund policies have to be brought to the client's attention at the time the charge is authorized. So what that means is you need some kind of clunky language here that says, I'm authorizing the agency to charge my card referenced above in the amount indicated and agree to the agency's terms and conditions of booking, which are located at this link, including the supplier's and agency's cancellation and refund policies, which may limit my right to a refund if I cancel or change my plans. I mean, that's a lot of stuff, right? But you need all of that in there. And there are different, this might not be exactly the language that Tern has put into their system, but Tern has put in language that I have looked at, and I promise you that it's got the stuff you need. So as long as you've got terms and conditions, if you don't have terms and conditions, you're done. But when you use Tern, they've got language that is compliant with the standards. So if you get that call from Funjet or Globus or Holland America or G Adventures saying, hey, your client reversed the charges. Can you prove to us that you had authorization? You can print out that authorization in Tern, give that to the supplier, and they will have what they need to defend the chargeback. And hopefully they won't lose, and hopefully they'll do it the right way. But it's going to make it more difficult for them to come after you because you've done everything the way you're supposed to. So that's already, you don't need to take a picture of this or a screenshot or write this down, because if you're using Tern, it's already in there. Okay. Okay, I'm going to pause and we're pretty much at the end here. So
this is great. I really want to like double click on that piece, Tom, because I think the number one question that we get is, and I think it's so key. One point I want to just like double click on really quickly is the supplier. If we go to the previous slide, it's the supplier cancellation and refund policy. It's exactly why when you're making something moving something into an authorizable state in Tern, you have to have both of those two items linked, or it cannot be physically moved into a ready to be authorized status per this exact requirement. So I just want to double click on that point for everybody. That's exactly why it's built this way. It's built in tandem with exactly what Tom's talking about. So that's one piece. The second piece, I think the number one question here, and you've spoken to it, but I think it bears repeating, is I have high-end clients and they don't want to go in and authorize this every single time. And you honed in on just how risky and dicey that is. And I think one of the things that, and we hear this all the time, and maybe if you could just speak to that one more time and just like, what that puts you at risk of as the advisor, because the supplier's protecting themselves, right? So yeah, maybe just one more time. I think we gotta just like really hone that one in.
yeah, well, so I'll tell another story. I had a client reach out to me and tell me that he booked a trip for his best friend, and his best friend actually took the trip, came back. The travel advisor asked his friend, "How was it?" friend says, it was the worst trip I've ever taken. The hotel was disgusting. I can't believe you sent me there. I shouldn't have to pay for that. The guy actually took the trip. But because it was his best friend, when final payment came due, the agent's best friend said, yeah, you've got my credit card number, just put it through. He didn't have a written authorization. He certainly didn't have the magic language. And he wound up having to pay, I think it was like $15,000 for his client's vacation that the client actually took. Client got his money back, right? So that's one example. On supplier, terms and conditions, a lot of times, and this is the way most agencies do it, because most agencies have to do it this way. It's just super clunky to get them to agree to the supplier's terms and conditions. But usually it's on a quote, it's on an invoice, it's on an email, it's on a itinerary that you send them. And if you've disclosed who that supplier is, then you're probably going to be okay. But by porting those things in automatically, that just makes it so much cleaner and safer for you. But if the client is not, I mean, I have high value clients too. I have a client who purchased who booked a hotel room in Greece that cost $20,000 a night, which my eyes popped out of my head. I couldn't believe it. They are very busy. They are high value, but you can rest assured that I insisted that they sign that terms and conditions document, that they authorize that charge, because I am not going to pay for that room if they decide to reverse the charges. I can't, I can't do it. So, I mean, I'm not that wealthy. I'm not charging enough for terms and conditions documents. So,
I mean, I think that is the right way to think about it. It's like, what are you willing to pay if it comes down to it, and that can get really scary, to your point, because those numbers can get quite high.
I think that's where the tech tool really helps, right? It's so much easier than,
Really.
I talked to somebody once who said to me, well, I don't want to force them to log into something and click and sign it. And she said, can't I just, if I've got the number on file, can't I just have them send me an email that it's okay? And I said, sure, but the email is going to have to say, I'm authorizing you to charge my card ending in 4567 in the amount of $1,254.67. And I agree to your terms and conditions of booking here's the link, including the suppliers and the agency's cancellation and refund policies.
Yeah.
And then I got, oh, well, so use a tech tool. It's
right.
easy.
Same thing. Yeah. That's really, really helpful. Okay. We've got quite a few questions on this category, which makes sense. Cool if we just start reading them aloud okay. We'll start with the first one. If, for example, you are booking a package through a DMC, i.e. FunJet, do you need to provide the terms and conditions, et cetera, for each component of the trip? Or since FunJet in this example is the supplier, do we only need to provide the policies for them to meet the requirement of disclosing our suppliers?
So really all you have to do is disclose that you're booking it through FunJet. You don't actually have, as long as you just this is the bare minimum. The bare minimum is you have to disclose the supplier, and then as long as they can figure out where they can find the supplier terms and conditions, that's fine. If a supplier, a tour operator, or a DMC has aggregated all of those things together, then you don't have to provide, oh, this is the ground transportation that they use, this is how much that costs. You don't have to break those things out. It's enough that your supplier is the person you're doing business with. Their suppliers are the people they're doing business with. So
makes total sense. Super helpful.
There's actually good case law on this out there. So as long as you're identifying who the supplier is, and as long as your terms and conditions say that they're automatically agreeing to the supplier's cancellation and refund policies, you're gonna be okay. You're gonna be okay, unless the courts decide something different.
And then Patricia asked, what about for recurring cruise payments? Can you authorize the total and document that it is for monthly payments?
I I want to say yes, but it's kind of up to the credit card company whether they would accept that. And the difficulty is that, I mean, I think I mean I would be comfortable arguing that point with a credit card company that was resolving a chargeback, that you had the authorization. You know, I mean, I guess there's the risk that they could say that something changed or circumstances changed and they withdrew their authorization, and then you get into a dispute about that. But I would generally say that I would say that if you've got the right language and you've got an authorization for the full amount, if the payments were made on a schedule, um, I think that's okay. But then keep in mind too that the credit card companies don't have any interest in making sure that you are protected.
Mm.
The cardholder is their client. They want to make sure the cardholder is protected. So, like under the Fair Credit Billing Act, uh, people have 60 days to submit a credit card dispute after the transaction is made. Well, credit card companies will routinely refund payments that were made a year ago, because they want to make their cardholders happy. They want them to keep their credit card. You know, Amex is particularly bad about this. So, just you know, make sure that you've got all the stuff in place. And you know, if you can set it up so that they get an automated payment reminder, so they just go in and click each time, that's that's something I'm pretty sure Tern's able to do, right?
Mm-hmm.
You can set up a payment schedule and they're
Yep,
able.
installments, exactly. Yep.
Yeah, so if they're authorizing each and every one, that's definitely the safest.
Yep, makes total sense. And that's exactly how it works inside of Tern. If you're authorizing something, you're authorizing a dedicated installment of that total amount. Okay, amazing. We're going to kind of go all around here because now questions are coming in for sort of all topics. Question from Connie. If we operate a standalone agency as the owner, but also are part of a host agency, does one set of documents work, or do we need to have two sets created?
So if you are so different host agencies work in different ways. So there are some host agencies, and I should say franchises, that they have their own terms and conditions. Generally, those terms and conditions protect the host agency. They don't necessarily protect your own separate business. If you are selling under your own brand, under your own nameplate, you should have your own terms and conditions. Well, I think you should have your own terms and conditions either way. If you're also using your host agency's terms and conditions, you want to make sure those aren't in conflict with each other. There aren't very many host agencies, though, that provide terms and conditions to their hosted businesses. I can't think of any of them that really do off the top of my head. But it's one reason. It's also one reason why. And I do a lot of independent contractor agreements for agencies. And when I draft an independent contractor agreement, I strongly recommend that if you're bringing on ICs, don't turn yourself into a host agency. Make them sell under your brand, under your nameplate. Make them sub-agents and not hosted businesses, because if they have their own brand identity, they can't really use your terms and conditions. You can't really require them to use your terms and conditions because you can't tell an independent business what to do, how to run their business. So if they're a sub-agent and they're selling under your brand, it's a lot easier to protect your booking credentials. It's just, they'll be covered by your errors and omissions insurance. Last time I asked Berkshire Hathaway about it, they said as long as they're booking under your brand, they're covered by your insurance. So I would say, you should probably have your own, and it should be customized to your specific business. There are a couple of host agencies out there where people are independent contractors that sell under the host agency's brand. They have email addresses from their host agency and things like that. Uh, I guess the question there is, to what extent is the host agency liable for your mistakes if you screw something up? But if they don't have a terms and conditions document that you can use, you should definitely have your own.
Super helpful. Okay, question in the tour operator realm. Is there legal guidance or precedent for what constitutes a tour operator?
It's not it's not cut and dried. So there are a bunch of factors that come into play. Whether if you host and escort your tours, that's one thing. If you white label the tours and sell them at a set price on your website, that's another strong indicator. Whether you do FIT trips, that comes into play if you do a substantial amount of FIT. But the thing that I think is really the thing that automatically turns you into a tour operator is if you don't disclose the principal supplier. If you don't tell them who the tour operator is, then you are the tour operator. Taking direct payments is another thing. If you take net rates and mark them up, that is something that's moving you out of the travel agency lane and into the tour operator lane. If you do all of those things, then you're definitely a tour operator. But if it's like one from column A, one from column B, but the rest of it you don't do, it's, there's a lot of gray in there, which is why in your terms and conditions document, you want to have a provision that clearly defines you as a travel agency, and you always want to disclose who the supplier is. And if you have those two things in place, that's going to help keep you in the travel agency lane.
Great. Super helpful. Erin, I'll pause. Anything you're seeing that you want to read out for Tom?
Yeah, so back on the subagents, Carrie had a good question. Should we call them subagents, or independent consultants?
You can refer to them as any of those things: independent advisors, independent contractors, independent sales agents, sub-agents. Any of those things are fine. What you call them is not as important as what's in your independent contractor agreement with them. I have a whole other presentation that might be on my website about working with ICs and having a really solid independent contractor agreement. You're not going to want to have a non-compete clause in there. You're not going to want to have an exclusivity provision in there. Those are things that can pretty quickly lead to it doesn't take much to trigger an audit. I have a client who was not a client of mine when this happened to her, but quickly became one, where one of her independent contractors filed an unemployment claim, and she sent it to her tax guy thinking it was a tax thing, and she got a notice of an audit because she didn't have unemployment insurance. She thought it was an audit for something related to taxes. Her accountant answered the questions the wrong way, and now she's facing a pretty substantial fine. But it doesn't take much to trigger an audit. You really want to make sure you're doing it the right way. But what you call them is not as important as how you treat them and what's in your contract, because the contract's the first thing they're going to look at when you're audited.
Got it. And that is the same if they were an independent agency owner or if they were under a host agency. It doesn't matter if they call them a subcontractor, independent contractor. That rule still stands if they're hosted.
Yeah, it'll be defined in the contract. So if you're a hosted agency, then your entire business is an independent contractor of the host agency. The independent contractor relationships are structured differently when you're a hosted business compared to when you're an individual, but they're still independent contractor relationships, and they still need to be defined and structured the right way.
Excellent, thank you. We had one question come in earlier, and I, again, not a lawyer, but someone asked if they approve a credit card authorization for 30 days with the verbal approval, does that work? I have an answer in my head, but I would like the lawyer to say.
Yeah, so the only way a verbal approval is going to work is if you've got them on tape saying, I agree to your terms and conditions of booking, which are located at www.tomstravelagency.com/terms and conditions, and I agree to your terms and conditions of booking, the supplier cancellation refund policies limit my right to a refund, blah, blah, blah. So like verbal doesn't work. It just doesn't, it doesn't work, period. Unless recording, and if it's a recording, they have to say exactly the right stuff.
Got it. And we had a few questions around terms, conditions, and supplier terms and conditions. And you did a great job of talking about this during your presentation, and we answered a few questions that Tern has it set up that in order to get an activity ready for credit card authorization, you're encouraged to enter the link to the supplier's terms and conditions and the supplier's cancellation policy. But then whenever they authorize that payment, there's also a checkbox linked to our terms and conditions that are linked to our account as well. So our question was, do we need them to agree to our T&Cs as well as the supplier T&Cs? Or
Yeah.
is agreeing to our terms and conditions enough?
Yeah. No, I mean, like the best practice would be having them agree to both.
Right.
And in the credit card authorization language that Tern uses, they are agreeing to both.
Yeah.
And then the other piece of that is that the terms and conditions have to be available to them, have to be conspicuous. And so the easier they are to find, the better. If conspicuous means they have to look it up on the supplier's website, well, it's still available to them. It's not ideal though. So Tern has put something together that is ideal. Basically it's a tech tool. Like I'll just say this, that like there are a lot of people. It's very easy to start a travel agency, and those of you who are interested in implementing a technology tool are the ones who are doing it the right way, because you're paying attention to this stuff and you actually took time out of your day to come here and start figuring this stuff out. There are so many people out there that are just ready, fire, aim with their business, and they don't know what they're doing. They don't even treat their business like an actual business. So you're doing it the right way. And Tern is set up to make you do it, to basically save people from themselves, because there are a lot of people out there that aren't doing it the right way. Some of those people might sign on to Tern and they might not have had the benefit of knowing all this stuff that we're talking about today. And so that's just a long way of saying, don't let the perfect be the enemy of the good, but Tern is pretty close to perfect on this.
We appreciate that. We had two kind of questions that are very similar to each other, but I think it could answer a few other questions that I've gotten from people in other lives as well. Regarding terms and conditions and a separate client agreement, can you put your client agreement verbiage in your terms and conditions, or is client agreements is that something you more associate with direct planning fees?
Yeah, so the terms and conditions document is the baseline for all of your trips, and the client agreement is like a vehicle to get people to sign on to your terms. So they're two different documents. You don't have to use a client agreement. In fact, I for my repeat clients, for clients who've already booked with me, I have them sign the client agreement the first time they work with me, and then if they come back to me for a repeat trip, I just have them agree to my terms and conditions through the credit card authorization language when they put the deposit down on their next trip. Because they already know about my fee structure. I've already talked to them about insurance. So at the beginning of the relationship, I have them sign my client agreement where they agree to my terms and conditions, and then they're agreeing to my terms and conditions an additional time when they make a deposit on their next trip, when they put insurance in place, when they add supplemental services, when they make their final payment, when they pay my fees. They're agreeing to my terms over and over and over again through the credit card authorization language. And it just happens automatically. Whether they go to my website and read my terms, that's up to them. Whether they click through and read the terms that you've uploaded to Tern, that's up to them. But when they check those boxes and they submit those credit card authorizations, it's easy for you, it's easy for them. Set it and forget it. It's like an instant pot of credit card compliance. You just put it all into Tern and you get dinner. So
the client agreement sounds like an excellent use of customizing a form in Tern, putting the client agreement verbiage in there, having a link to the terms and conditions in your client agreement. But that could be an excellent use of creating a custom form in Tern.
Great. I can speak to, there's some questions coming up in the chat on the Tern side about, to exactly Aaron's point there, like a signature block on forms. That is something that's like very top of mind. We're actively working on it. We will certainly add in favor of exactly kind of this topic. But I think the thing we really wanted to clarify actually before we do that is have this space to have this conversation, because that is not a direct replication of what your terms and conditions should be, just because there's a signature block on a custom form. But all that to say, there is very much still a use case for it, and we are actively working on it.
And someone asked me this a few days ago, completely outside of this chat, but are website terms and conditions the same as what you're talking about, terms and conditions? Again, I have an answer in my head, but I would rather hear it from the lawyer.
Yeah, so website terms and conditions, website terms of use is different than website, or different than booking terms and conditions. So booking terms and conditions are for people who are booking travel with you. Your website terms and conditions are for people who, visit your website, kind of check you out, see what you're all about. It'll say things like they can't steal your blog posts, they can't steal your photos, they can't, if they get a virus or a worm or malware from your site, you're not responsible for those sorts of things. So that's for people who visit your website who may never actually book a trip with you, but visit your site for one reason or another.
Got it. So website terms of use, privacy policies on your website, good to have, but different from your agency's terms and conditions.
Yeah, and on privacy policies, I think a lot of times people get into the weeds on what they need from a privacy policy, because the data privacy laws that are out there, like the California data privacy law is the one that everybody's concerned, started getting concerned about a couple of years ago, because California passed this data privacy law. They didn't provide a lot of guidance for how to comply with it, but now that's why when you see websites, the thing pops up that says this website uses cookies. That's because of California. The thing about it is the California data privacy law only applies to businesses that are doing $25 million in sales to California residents or more, or are collecting data from 50,000 users in California. So, I mean, that's not most of my clients. That's not me. I mean, I wish I 25 million a year in sales, but so if you don't have a privacy policy right away, I don't think you're sitting on a ton of liability. There are other states that have similar laws, but again, if you have, if you're doing $50 million in sales from people who live only in the state of Virginia, yeah, then you should talk to a lawyer about having something that's really solid. But the booking terms and conditions are, for most of us, what's going to really protect us.
And to that end, Tom, like how do suppliers protect themselves from this? Like we think about like a kind of worst case scenario chargeback situation. Like I mean, suppliers there's a lot in place to protect from their side. And so this really does this in a kind of nightmare scenario does come back to the advisors. Like what are suppliers doing to protect themselves from this? And how does that impact the advisor?
Yeah, so there are a lot of suppliers who have started sending payment links so that the client can make the payment directly to the supplier without you handling their credit card number. People have asked me whether that's okay. For some reason, people think that that's a bad idea. It's actually really helpful, because then you don't have to worry about it. You just send the payment link to your client makes the payment directly to the supplier. The client authorizes it with the supplier. You don't touch their credit card number at all. And then you get a commission check at the end of the trip. So like that's the easiest way to do it. That's the cleanest way. And so like suppliers like G Adventures, I know has started sending client links, and only they're trying to only take money or only take payments directly from the cardholder.
Helpful. I know you said this, but we had a few, maybe we can kind of round it out here. Because I think, the goal is to sort of like the goal of this informational session is to sort of demystify some of these are big topics, and these are really important topics. And so Tom, we're just so grateful to you for taking the time away to kind of help us do that. Of course, given your tremendous expertise in this area. The size of the risk though, like maybe just kind of one more time, like what is the size of the risk if something goes wrong here and an advisor ends up in a chargeback situation?
So the risk is that you're going to have to pay for it. I mean, that's the risk. So the size of the risk is the amount of the charge, essentially. So if you've got somebody who's booking a $25 transfer, if you can find a $25 transfer, if you've got somebody who's booking a $25 transfer, maybe you're fine. You know, maybe
Mhm.
you just need to prepare yourself that you're going to have to pay $25 if they do a chargeback and it redounds back to you. If your client books a $15,000 um, uh, trip, a $20,000 trip, a $50,000 trip, you know, they're taking grandma and grandpa are taking all the kids to Antarctica. I mean, that's, you know, hundreds of thousands of dollars potentially that you're going to have to pay for if you didn't have an authorization. And if you don't have a terms and conditions document and you don't have an authorization, there's just no way that you're going to survive that. You're not going to win a chargeback dispute. There's no way to win it.
Yeah.
So, you know, I mean, there are other reasons to have terms and conditions documents aside from just I mean, the credit card authorization is one thing. You know, that's money, but you know,
Yep.
the terms and conditions document, you know, if a helicopter crashes on a glacier and you don't have a limitation of liability policy, you know, when they file that lawsuit, they're going to bring everybody and anybody into it. And if you were the one who booked them, they're going to say, well, I mean, I had this happen. It always seems to happen with destination weddings, but
Mm.
something went horribly wrong at a destination wedding, and like the groom's father was like somebody broke into his room and stabbed the groom's father, and then you know, they still had the wedding, and there's like all this crazy stuff that happened. And you know, there's a risk that when that lawsuit gets filed, the travel agent, you know, if they file it, they're going to attach everybody and anybody to it. And you know, if
Yeah.
terms and conditions document that says I'm not responsible for things that go sideways on your trip,
Hmm.
agree to that, it's going to be a lot easier to get you out of that lawsuit than I mean, just selling travel is, you know, go back to the first slides. Selling travel has a huge amount of risk,
Yep.
but you can deal with all of it. Like
Yep.
I mean, I really do want that to be the takeaway, that everything everything horrible that can happen that can destroy your business and your life and your finances, all of that is stuff that you can deal with. And you know, Tern is a big part of managing that. Errors and omissions is another part of it. Having the right documents and policies in place, being consistent with your workflow, and then just getting a credit card authorization each and every time. If you do all these things consistently, it doesn't mean you're not going to have to deal with problems. It just means that those problems are going to go away a lot quicker and a lot easier. So
That's so helpful and such a great, eloquent recap to kind of end the session with. Tom, thank you so much. For everybody else, yes, we will circulate the recording, and we will make sure that we sort of like, you know, document the FAQs that were asked and shared here. But please, all the kudos and all the shout outs in the world go to Tom. Thank you so much for joining us. This was super helpful. I can tell that this was, by the way that people are sending things into the chat, that this was tremendously useful for folks, which is great, and such a testament to you and your partnership with our team. So thank you so much for everything.
yeah, well, I'm really grateful for the opportunity to talk about these things. I mean, being somebody who owns an agency as well, I have a strong view that the more of us who can get all our ducks in a row and protect our businesses, because when like bad stuff starts happening in the industry, it trickles down and it affects
Yeah.
all. And so, you know, I am grateful, not just to Tern, actually, to the other tech companies that are out there that are providing tools that
Completely.
easy for people to comply with. I've worked with some of those other companies. They are really good people. The team at Tern has been fantastic to work with. So I am grateful for the opportunity to talk to people. I'm grateful that people came here, and I'm grateful to Tern for developing something that's really so.
Awesome. You're so sweet. Thank you so much. And thank you to all of our advisors for the amazing questions. Thank you for tuning
Yes, thank
in.
you.
These sessions are only as valuable as the folks that show up and ask amazing questions. So thank you all so very much. And everybody have an amazing rest of your Thursday. Thanks so much. Bye, everybody.